all
So,
on?
excuse me, Judge. There's an echo from Sandla Zikatla.
From whom?
Sandla Zigatla. I must apologize, I might be pronouncing it incorrectly.
Can you reduce your volume, please?
Yeah. Or even listen on yours, Mr. Maleka. Just switch it off completely. Was in the same room. It causes not not yours. Yes. Are all council online?
Judge, I'm certainly here. I can't tell whether junior counsel is here. Let me just.
I was asking. Thank you very much, Mr. Dawson. The case caller, Ms. Suraj Paul, please. Or Justice Theron, can you assist?
Yes, the Justice Madlanga, thank you. The only person
I'll raise the iPad. Yes. iPad 65. Yes. Is that one of the representatives we should admit? iPad 65. It seems not.
Then everyone is online, Justice Madlanga.
Yeah. Yes, Mr. Maleka.
I'm sorry to interrupt. I believe that iPad 65 is that of Mr. Kunju, who is my junior in this case.
Has he been admitted? Do you know?
Yes.
Please admit him if he has not been.
He was admitted a few minutes ago on another link.
All right. Let's start then. Let's start. Thank you very much, Mr. Maleka. Yes, Ms. Suraj Paul.
Morning. I am the Registrar Clerk for this hearing. Justice Madlanga and Justices of the Constitutional Court, all counsel are online. I call the matter of Municipal Manager, OR Tambo District Municipality and another, and Nosipho, Portia, and Ndabeni for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Thank you.
May it please the court, Justice Madlanga, I appear on behalf of the applicants, together with my learned friend, Mr. Apla Budlani.
Thank you. Thank you, Mr. Dodson.
Good morning, Justice. I appear for the respondent, together with my colleague, Mr. Kunji.
Thank you, Mr. Malek. Yes, Mr. Dodson.
As the court pleases. Justice Madlanga, as a starting issue, the applicant needs to apply for condonation for the late filing by a week and 3 days of the record. We submit that a proper case has been made out in the heads of argument and ask for relief in that regard accordingly.
It seems you have or is the problem on my side? Maybe it's on my side because I'm the one who has load shedding. Do my colleagues and everybody and counsel, do you hear Mr. Dawson perfectly well? No glitches?
I don't, Justice Madlanga. I suspect it's on his side. That's my suspicion.
I was hearing him quite well.
Quite well. Or then the problem is mine. I'll continue, Mr. Dawson. It's not that I don't hear you. Please continue. Mr. Maleka, do you have any objections to the condonation application?
No, we don't oppose it.
All right, leave it at that then, Mr. Dawson, and just make your submissions on other issues. And your 10 minutes starts now at 10:03.
As the court pleases. 2 questions are raised by this case. Firstly, did Justice Mjali order relief that could not be granted under Section 66 of the Systems Act, resulting in nullity and an entitlement to disregard it? Second, whether or not this was so, was the late Mr. Owen Klazo acting in good faith in deciding that he was bound by Section 66 not to act in terms of the order? We start with the second question. Our submission, though, will be that both the questions stand to be answered in the affirmative. The The second question raises the issue of whether or not there was willfulness and bona fides. We submit that in considering this question, it is important to bear in mind a number of factors. The first is that the evidence put up by the applicants explaining their position was uncontested. This is because the respondents chose not to plead over, instead pursuing an unsuccessful strikeout application. This court made it clear in Helen Suzman Foundation that a party seeking a strikeout must still plead over. In any event, the applicants had the benefit of the rule in Plescon-Evans to get past that. I beg your pardon, they had the benefit of the rule in Plescon-Evans to rely on their version prevailing. To get past that difficulty, the respondent needed to apply to have the municipal manager subject himself to cross-examination or to have the questions of willfulness or bona fides referred for the hearing of oral evidence. She did not do so. The majority of the Supreme Court of Appeal was able to get past the uncontested nature of the municipal manager's evidence by finding that he in effect confessed to willfulness and bona fides. But in doing so, the majority overlooked the crucial introductory words, "I deny that," in paragraph 37 of the answering affidavit in the contempt application. If there was any doubt about the municipal manager's denial, it was made up front early in the answering affidavit at page 29, paragraph 9, when he said, "I would explain the failure to comply as well, so as to satisfy this court that the parties against whom the contempt of court application lies did not intentionally defy the terms of this order." In Mwelasi, this court was concerned with an order that compelled the parties to negotiate in good faith in order to agree on a memorandum of understanding dealing with, amongst others, the establishment of a national forum of NGOs. One of the parties, the Minister of Rural Development and Land Reform, unilaterally established the national forum. When faced with the contempt application for non-compliance with the order, he said that he understood the order to allow or require him to act unilaterally. The court held as follows at paragraph 76 to 77. It is not possible on the affidavits before us to infer that the minister acted in mala fide. Making an inference of bad faith in the face of an affidavit denial will unfortunately often prove difficult. It certainly was here. The alternative, to ask the court to order evidence under oath with cross-examination, will certainly pierce the paper defense the affidavit provides. But the applicants did not ask for that here. It follows that their attempt to overturn the findings on the contempt issue must fail. We submit that in this case, the explanation provided by the late Mr. Owen Plaza, the municipal manager, was far more convincing than the minister's explanation in Mwelasi. On this basis alone, we submit that it cannot be found that he was either willful or mala fides, and on this basis alone, we submit that the appeal stands to be upheld. If I can then turn to the first question pertaining to the nullity of the order. A crucial and we submit dispositive factor on the first question is that the parties on both sides and both the majority and the minority of the Supreme Court of Appeal agree that at least paragraph 2 of the order of Justice Njali was a nullity because it was in breach of section 66(1) of the enabling legislation. This because it has the effect of creating a permanent post in the municipality staff establishment when this is in fact the exclusive preserve of the municipal manager, acting with the approval of the municipal council. That's dealt with in the respondent's heads, it's paragraph 50 and 51, and it's dealt with in the majority judgment as reflected at page 160 of the record, paragraph 24. The Supreme Court of Appeal, in fact, went further and held that paragraph 2 of Njali J's order falls to be deleted. The respondent says that that cleanses the order of any unconstitutionality, leaving the balance of the order beyond question. However, we submit that the inescapable corollary of that finding is that there is no post of attic manager on the municipality staff establishment. Once that is so, and that it is so supported by the uncontested organogram put up with the answering affidavit, there is no lawful basis for any of the relief in paragraphs 1, 4, and 5 of the order. Section 66(3) is in the clearest terms. It says, no person may be employed in a municipality unless the post to which he or she is appointed is provided for in the staff establishment of that municipality. This is both an original and a continuing statutory obligation. The effect of paragraphs 1, 4, and 5 of the order is to require the municipal manager to proceed on the basis that there is a permanent contract of employment between the municipality and the respondent. But section 66(4) makes it clear that any such contract and the decision to conclude it is from the outset unlawful, null, and void. It says in express terms, a decision to employ a person in a municipality and any contract concluded between the municipality and that person in consequence of the decision is null and void if the appointment was made in contravention of subsection 3. So once it is accepted that paragraph 2 of the order is void, we submit that the entire house of cards falls. The order in its entirety is invalid. In relation to willfulness, and just coming back briefly to that point, willfulness and mala fides, the concession that paragraph 2 was invalid vindicates the stance of the municipal manager. His fear of implementation of the order was squarely based on the fact that the position of attic manager was not part of the staff establishment. The majority of the SCA, in effect, was saying that he was quite correct. Although it is not necessary to go further to uphold the appeal, that consensus regarding paragraph 2 also disposes of any scope for reliance on the resolution. Assuming the existence of a resolution as contended for by the respondent, it was a decision to create new permanent contracts of employment to replace all temporary contracts of employment. That fell squarely within the ambit of a decision and resultant contract under section 66(4). But because no post existed on the staff establishment of attic manager, section 66(4) renders it void. So we submit that that concession in relation to paragraph 2 determines that the order is in fact invalid, and on that separate basis too, the appeal stands to be upheld. I can then turn to the invitation by the respondent to overturn paragraph 14 of the Mutala judgment. The respondent asks this court to overturn Mutala and Norman Din on the basis of stare decisis, and in particular the fact that this court reconfirmed Tasima with, as they put it, decisive force in the second state capture judgment. Before dealing with that judgment, it must be noted that a distinguishing feature of the enabling legislation in this matter is that nullity is expressly provided for in the statute in section 66(4). Accordingly, even if this court were to overturn paragraph 14 of Mutala, that would not dispose of the matter. The nullity provision is a distinguishing feature of this case that would render the order invalid whether or not paragraph 14 of Mutala was overturned. In any event, we submit that the second state capture judgment does not do away with Mutala. It is entirely distinguishable. It did not involve a situation where it was contended that the court order was a nullity. The court did not refer to or deal in any way whatsoever with Mutala, expressly or impliedly. There is a single passing reference to Tasima in paragraph 60 of the court's judgment, and the court did not seek to revisit or qualify in any way the crucial paragraph 197 of the Tasima judgment, where this court recognized.
I'm sorry to stop you mid-sentence there, Mr. Dodson. The 10 minutes is up and questions may be put to you now. Let me just raise the difficulty that I have. If you look at a case like Mutala, I will at this stage not bother about the question whether that should continue to be law. I will proceed from the assumption that it applies. The difficulty that I have is that with a case like Mutala, you are able to just look at the law and look at the order that was granted. Facts are completely irrelevant, and you are able to tell based on the law and based on the order, looking at everything ex facie, this order is unlawful. It has no legal basis whatsoever. Now, my difficulty with this one is there just have to be underlying facts. There is, for example, the issue of, at a factual level, does this post exist on the organogram? That's a factual issue. So the court must first go into facts before it then holds that this is a nullity, if it can hold that at all. Does this case even, is this case even covered by the Mutala principle? I might add a second question, and if you can note both and deal with both one after the other. The respondents make the point that Justice Jali J made a factual finding that in fact this post does exist, and that all that happened is that its name was changed. And the respondents refer to volume 2, which page is it? 170. Let me see if I can find that quickly. Volume 2, page 176, lines 9 to 21. So it seems to me, at least at face value, and depending on what your response is, that we may well not even get to Mutala at all. What is your response?
Justice Madlanga, I would submit, and perhaps we can take a look at the order, and it follows from the argument that I presented. We would submit that there is in fact facial non-compliance. If one looks at paragraph 2 of the court order at page 301 of the record, we would submit that the wording of the order makes it clear that the court is in fact performing the function of the municipal manager in terms of section 66(1) of the Act. It says the post referred to as AIDS Training Information and Counseling Center Manager, previously occupied by the applicant, is hereby, in other words, is by this order, declared a permanent post in line with resolution number 10/11 of 30 January 2011. So we submit that that is not simply, as the majority in the SCA suggested, a declarator as to an existing set of facts.
At a factual level, how do I know that resolution 10/11 did not exactly create that as a permanent post? How do I know at a factual level? You would have to go a step further.
We would submit not. If resolution number 10 of 11 did in fact establish that particular permanent post, there wouldn't be a need for paragraph 2 at all in the order. The order could
if parties do not agree, there's an issue, and the very fact that Ms. Ndabeni had to go to court, there was an issue around this. So she was perfectly entitled to a declaration of rights.
But we would submit that the order would have read differently if it was not doing that. The order would have read to the effect that it was declaring an existing set of facts to be the case. And it didn't do that. It says, is hereby declared.
Once we start debating, would it have read better if it said this as opposed to that and so on? I'm not altogether sure that it takes us within the realm of Mutala. I'm not sure about that,
That's the submission we make, and we submit that, there are two components to it. The first component is why is it there in the first place? Three components to it. Why is it there in the first place? The second component is we say that if it was simply declaring a fact, it wouldn't have to say is hereby declared. It would say words to the effect that was created by resolution number 10 of 11. It's not a historical, a declarator would have a historical declaration. This is prospective we would submit on the wording of the provision.
I will not belabor that one. Let's move on to the factual issue then by Justice Mjali J.
If I may just turn to the particular portion of the record.
(176) lines 9 to, you'll see it somewhere there, I think in the 20s, lines 9 to the 20s somewhere.
I can't immediately recall what the precise finding of Justice Mjali was in that regard, and I can't immediately.
She says in so many words that the name of the post was changed to something else. Let me just find it.
Justice Madlanga from line 11.
Yes.
From line 11 in that page.
I threw my relevant volume away. Thank you very much, Justice Chikli. Just have a look at that 176. You will see it, Mr. Dodson. The justice says in so many words, 11, the applicant has a record of such a period and also the record of salaries and benefits pertaining to that post. The mere fact that the designation changed to senior coordinator manager in the approved organogram does not render the order granted incapable of being put into effect, as on the papers the respondent makes it clear which position she sought to be absorbed in.
The difficulty with that is that the reference to the earlier period of employment is a reference to a period as a temporary employee. So if it refers to a post, she cannot be referring to the post that we're currently talking about, because she's referring to a temporary position held on a contract basis. So that can't form the basis of an assertion that she made a finding that a permanent position of attic manager on the staff establishment existed. All she was saying is that, referring to the past, if one looks at her order and if one looks at the facts, all she is saying that she occupied that position as a temporary contract employee, which was common cause effectively. It was not a permanent post in that position that she was occupying.
I will not hog the space, but I may come back later on. I want to give an opportunity to my colleagues.
Perhaps if I can just come.
Yes.
Mr. Dodson,
sorry, my sister, yes. Mr. Dodson says he wants to just finish his response. You may come in when he is done.
Okay, thank you.
Sorry for that. Yes, Mr. Dodson.
Yes, again, just a brief observation in relation to senior coordinator manager is that, in fact, if one looks at the organogram, that position doesn't exist either, and I will take the court to the relevant provision as far as that's concerned.
Thank you. Yes, my sister.
Because Justice Madlanga had raised it now by Mr. Dodson, I thought that perhaps we should finish that paragraph, because you've now said that Jali J is referring to previous employment. That is now the the part-time employment. But she then says, if you read down in that paragraph, she says the council took a resolution to convert contract posts to permanent employees. And then she makes the point that once a resolution, and then she says the council had resolved to convert these posts to permanent posts. And then she says that once that resolution was adopted, it was binding on the municipality. So she doesn't just leave it there. She realizes that yes, it was a temporal post at some stage, but she says that in the light of the fact that the municipal council had taken a resolution to convert those contracts to permanent contracts, the municipality was bound by that.
But the resolution on its own terms only provides for the conversion of contracts from temporary to permanent. It doesn't at all address, even on her own version, the question of whether or not there were posts in the staff establishment. That's a question that still has to be answered, and the position still has to be there as an express requirement of section 66(3) before that resolution can be effective.
Was it in dispute, Mr. Dodson? Because I'm really not clear about this. Was it in dispute that the resolution was that all temporal posts must be converted to permanent posts? And was it also in dispute whether Ms. Ndabeni was one of the temporal staff members?
Indeed, Justice Cheeky. If one looks at documents that the respondent herself put up in the contempt proceedings, those demonstrate that that is a hotly contested issue. And I will take the court to those particular provisions. And it's an important component of this case because one has a situation where she herself, in her replying affidavit, takes the previous petition to the Supreme Court of Appeal and attaches that previous petition to the Supreme Court of Appeal to her replying affidavit. And there are a number of indications in that record that there was serious doubt as to whether or not this particular resolution benefited her. And she provides no explanation of that. So in the contempt proceedings, even on her own version, that is in dispute. And if I can perhaps just take the court to the relevant parts of the papers. First of all, if I can ask the court to turn to page 295. There, and this was the founding affidavit of the municipality in the petition to the Supreme Court of Appeal in paragraph 20.4. Further, there is no evidence that the post exists on the first step applicant's organogram. It would appear from the annexes to the respondent's founding affidavit that the court order promoted the respondent. Annex ND6 is a letter addressed to the Superintendent General of the Department of Health requesting the implementation of the municipal resolution to convert ATIC employees from contract to permanent, pursuant to the process of transfer of the function of ATIC from the district municipality back to the province. A copy of the letter is next marked NH10. In Annex ND8 of 29 September, after the resolution of 30 January 2011, the respondent herself confirmed that ATIC services were provincialized in 2012. She further unambiguously advised that her position is not an ATIC manager as per current approved organogram. Her post was that of senior coordinator manager according to the organogram. Copy of the letter is next marked Annex 11. In Annex ND10, which is a letter addressed to the respondent's legal representative, it is made plain that the Provincial Department of Health is a major stakeholder in this matter as the employer of Ms. Ndabeni. To this, the respondent's attorney demanded reinstatement of our client's status quo. A copy of the letter is attached marked NH12. And those letters then appear at pages 324 and following. So the first is a letter of the 7th of June 2012, which is addressed to the Superintendent General of the Eastern Cape Department of Health. And the opening paragraph says, pursuant to the process of transfer of the function of ATIC from the district municipality back to the province and the incidental transfer of ATIC staff, we wish to advise as follows. The ATIC staff were employed on contract, fixed term, and were thus not permanent employees of the municipality. The council had taken a resolution to convert the contracts of employment of contract employees to permanent employees, and the council memorandum recommending same are attached for ease of reference. This resolution applied to all employees from salary post level 4 upwards, including all ATIC staff. Excluded from this resolution were those employees occupying positions of municipal manager and so on. And importantly, paragraph 4, the process of the implementation of the said council resolution had been completed, and it was therefore decided, had not been completed, and it was therefore decided that due to the transfer process, conversion of ATIC staff's contracts should be halted. In the light of the above, your office is hereby requested to implement the conversion of the said ATIC employees' contracts of employment to permanent employment. My office is willing and available to assist you in whatever way possible in this matter. So compelling evidence that in fact she was no longer the employee of the municipality, and it's evidence that she puts up and nobody else. Then there's a letter under her own hand.
If I may, because I think this is a very important aspect. If I may just see further clarity on your question. Mr. Dodson, as I said, I think this is an important aspect. And the first aspect that my sister Justice Chitke put is, and can we get some agreement or the position of the applicant that all contract employees were to be made permanent, and this was as per the resolution?
Well, that's her allegation, but she has also put up an incomplete version of the resolution, and even that doesn't confirm that.
Okay, Mr. Dodson, what is the applicant's position? Was the intention of and the effect of the resolution meant to be that contract employees were to be converted to permanent employees? I think I may have muted towards the end.
Yes, but there were, if one looks at the resolution, conditionalities attached to some of them, which seem on her own version to have applied to her. So, for example, approval
of the difficulty here also that the applicant hasn't put sufficient information before us.
Well, we would submit that there is sufficient information has been put up to demonstrate that there is indeed an irresoluble conflict with Section 66.
Okay, let's just go back a minute, Mr. I'm really sorry, Justice Tiki, if I may proceed.
Proceed.
Yeah, thank you. Did the applicant fall into the category of contract workers that were covered by the resolution?
Seemingly, yes, subject to the requirement of approval from the Labour Forum.
So let's assume that some of the positions had not yet been created on the staff establishment before the resolution was taken. Am I correct that in order to give effect to the resolution, the applicant may have been required to create further posts on the staff establishment?
Indeed, Justice Tron.
So the fact that that post which the applicant should have been occupied was not created by the applicant. The fact that the post which the respondent should have been occupying on the staff establishment as per the resolution, and that was not created subsequent to the resolution, surely the blame for that cannot be placed at the door of the respondent. And the applicant cannot say, well, I didn't do what I was supposed to do in terms of the resolution. I didn't create the post which the resolution authorized me to create and which I had to create in order to give effect to the resolution. I didn't create the post, therefore Section 66 is not complied with and the respondent's not entitled to be a permanent employee. Does it lie in the mouth of the applicant to say that?
We would submit that it lies in the mouth of the municipal manager as the leading official of the municipality to say, I am the person who designs the staff establishment, yes, subject to ultimate approval of the municipal council, but it's my jurisdiction, it's my territory. And he has with that the protection that's afforded by section 66.2 and 66.3 and 66.4. And he needs to guard that jealously, because if it is breached, he then ends up being personally liable in terms of section 66.5.
But he also had a resolution which he needed to give effect to. And you have, if I understood you, conceded that he may have had to create more posts on the establishment to give effect to that resolution.
Well, he isn't automatically bound by the municipal council when they pass a resolution of that nature. The discretion is his initially to establish a staff establishment. It's his discretion and nobody else's as a starting point. So there
So are you
can't be.
suggesting then that the resolution might not be worth the paper it's written on if the municipal manager decides not to act in accordance therewith, in his discretion?
Indeed, Justice Turon, and has the protection of the nullity provision. The cart came before the horse. What should have been there first is a process of creating a staff establishment that's compliant with section 66.1, that recognizes and respects the function of the municipal manager. And after that one gets a resolution. If a resolution is passed first that creates positions for which there are no posts, the automatic nullity provision in section 66.4 will kick in.
So why was the resolution never set aside?
We would submit that there would be no need to set it aside. It would also appear from the letters that I was making reference to, and indeed the applicant's own letter, that in fact a subsequent decision had been taken to the effect that those positions would be moved to the provincial department, and that was given effect to. She refers in her own letter to the provincialization.
Before you go to what she refers to, Mr. Dodson, on the Ouderkraal principle, would that resolution not be valid until set aside?
We would submit that the Ouderkraal principle doesn't apply in circumstances where there is an express provision for nullity, as we have here in section 66.4. We say that creates a completely different statutory scenario. The Ouderkraal principle is essentially based on a presumption of the validity of administrative action. In this particular case, section 66.4 says that a different approach is going to apply here. The legislature lays down that from the outset, if administrative action takes place that is in conflict with those provisions, it is null and void from the beginning.
Thank you for the indulgence, my sister, Justice Triti.
And most of the questions I wanted to engage you, Mr. Dodson, on, my sister has asked those. I think let me pause for now.
If I could just, Justice Chiki, just to, I beg your pardon.
No, sorry. I was going to ask on the assumption that my colleague was at an end, but you wish to still answer her something.
I just wanted to draw the court's attention to the remaining references to the letters, and the letter under her own hand is at page 326.
Mr. Dodson, my apologies, my brother Justice Rogers. It's something that relates to exactly this copious reliance on Annexure NP8, which is the petition to the Supreme Court of Appeal in earlier proceedings. And I have had a look at the relevant paragraph where Ms. Ndabeni introduces does she call it NP8 or PN8, but its number is annexure number 8 to her answering affidavit in that petition. And she relies on it referring only to one paragraph of that petition. Now, the applicants before us now rely on that entire document. And my understanding of the law, I may be wrong, and please correct me if I am, is that if a party wants to rely on something that arises from an annexure, they must pertinently raise it and draw the other party's attention to that issue. I can think of, for example, the case of Khalisa versus Port Noloth Municipality. It's a judgment of the CPD, but there is a judgment of the then AD. I've forgotten, is it Teletsane or some? I may be wrong on Teletsane, but there is a judgment of the AD that makes the same point. And now, is it fair? Is it fair for the respondents to then be the applicants before us to be at large on that annexure and go wherever they want to on issues that were raised in proceedings before a different court in different, yes, of course, related proceedings. And they raised that before us, and it's now an issue being raised in affidavits before the Constitutional Court and not affidavits before the High Court.
This was before the High Court. This particular affidavit was indeed before the High Court in the contempt proceedings.
I thought you said it's an answer in the petition before the Supreme Court of Appeal.
Yes, it is.
That's how you identified it.
Indeed, but it is attached by Ms. Ndabeni to her replying affidavit in the contempt proceedings. So, to answer your question, yes, she attached it to her replying affidavit. The rule is that she can only rely on what she cross-refers to. But with respect, the rule can't operate the other way. If she puts out documentation that supports the case of the applicants,
you are obliged to rely on whatever part of the document.
We would submit that we're obliged to rely on it. And I think it's important that one is dealing here with a contempt application. Whatever approach one lays down here would apply equally on the question of nullity, would apply equally to a person who was in fact facing committal. So there's a difficulty with adopting an attitude in relation to where we are now in the contempt proceedings to say that the question of nullity will only be judged by the question of whether it's facially null. One is dealing potentially with a situation, as almost happened here, where a person is facing committal to prison. And with respect in those circumstances, one must be able to go back to all of the information, particularly here where it's been put up by the applicant, not by the respondent, and presents a clear defense and a clear explanation of why that resolution in fact didn't apply to her, that there were subsequent developments that made it not apply to her.
Thank you. I'm sorry, Justice Rogers.
Yes, Mr. Dodson, the application which has given rise ultimately to these proceedings before us was, if I can call it on the substance, there were two elements. The one was to declare your client's non-compliance with the previous order unlawful, and the other was to declare it in contempt. I'd like to leave the contempt aspect aside because mala fides and willfulness may depend on the particular facts. But the declaration that the non-compliance was unlawful, you'll accept that doesn't depend on whether there was contempt or not. It would simply declare that your client was obliged to comply with Mjali J's order. So even if there wasn't contempt, the declaration of its non-compliance being unlawful could still stand. And that depends on whether the Mjali J's order was a nullity.
With respect, it seems not, because if one looks at the order, if one looks at the, I beg your pardon, if one looks at the relief that was sought, if I could just find that, and perhaps it's best if we,
it's paragraph, it's page 2 of the record in volume 1. The rule Nisi called on the municipality to show cause why its conduct in failing, well, that was the manager, failing to comply with the order should not be declared unlawful and in contempt.
Indeed, I would, in the component that says unlawful, I would accept that that is so.
So assuming your client wasn't guilty of contempt because it bona fide thought the order was a nullity, the question of lawfulness requires us to answer the issue whether Njali J's order was or was not a nullity.
Indeed.
The material, the letters you've been taking us to were not, as far as we know, part of the record before Njali J. In fact, you now criticize Ms. Ndabeni for not having put them before the judge.
I'm not sure that I'm not sure. Yes, no, indeed.
Yes.
Yes, Justice Rogers, we do make that criticism, indeed.
So this material wasn't before the judge who made the order that is said to be a nullity.
Indeed.
And an order can't be a nullity because it is said to be wrong on the merits or because the evidence was incomplete. Those sorts of criticisms don't give rise to a nullity unless you rescind the judgment because it was obtained by fraud or some such complaint. Your complaint is not that the order was wrong on the merits. Your complaint is that it was a nullity.
Indeed.
Now, although the power to create the permanent establishment and put posts on it may vest with the council and the manager, you will accept that in the exercise of their powers, they are subject to the judicial review powers of a court.
Indeed.
And also, as I think the presiding judge put to you, if there's a dispute as to whether something is on a permanent establishment or not, a court can make a declaration in that regard.
Indeed.
And the fact that you consider its declaration to have been wrong on the merits, because your client's version, for example, just in a theoretical case, had been that it wasn't on the permanent establishment, that doesn't mean the court doesn't have a jurisdiction to make a declaration on that subject matter. It would be a criticism that it came to the wrong answer.
Indeed.
And the remedy would then be an appeal if it came to the wrong answer.
Yes, indeed.
Now, I'm puzzled by, I'm inclined to agree with your criticism that the SCA didn't have the power to interfere with Njali J's order by deleting paragraph 2. But it seems to me paragraph 2 was almost, was an important part of her reasoning. She was effectively saying the effect of this resolution was that this position is on the permanent establishment. Now, you may disagree with that, and it was a decision arrived at because your client was in default, but for better or for worse, your client decided to live with the order. I struggle in those circumstances to see why it was not within the jurisdiction of the judge, whether she was wrong or right, to say, I conclude that the effect of this resolution and the evidence that I have about the nature of Ms. Ndabeni's position is such that it is on the permanent establishment. I've heard what you said to the presiding judge about the way paragraph 2 is formulated, but I would have thought a declaration by its nature is not creative. It is declaring a position. That's the essential nature of it. It declares that which is. That's the nature of a declaratory order.
But if one looks at the particular wording, our submission would be, and certainly all of the judges on the Supreme Court of Appeal seem to have understood it that way. If one looks at the wording, it is not wording that is declarative of an existing situation.
It may not have been declarative of an existing situation in the sense that if you had gone to the organogram, you would necessarily have found it there. It may have been declaratory in the sense that the council had taken decisions by which in law the effect was to make this a job on the permanent establishment, whether or
But-
not the municipality yet recognized it to be so.
But we submit that on the particular wording of paragraph 2, that conclusion also can't be reached. We
Well,
say
that-
it's
Sorry.
we say that if one looks at the wording, it is by the order establishing a position which hitherto did not exist, because it says is hereby declared. It doesn't say I declare that by resolution so-and-so a permanent post was established. It says
If we were to interpret paragraph 2 as the judge declaring her understanding of what the position was in view of the decisions taken by the council and the allegations made concerning the nature of Ms. Ndabeni's position, in other words, if we are not with you on the creative power of paragraph 2 of the order, do you accept that whether that declaration was right or wrong, it was within the jurisdiction of the judge to make it?
yes.
Yes, thank you.
Mr. Dodson, your time was up 2 minutes ago. How much more time do you want?
Can I just take a quick look through my notes to see what's been left unattended? If the court will bear with me for a moment.
Mr. Dodson, can you help me with a few answers, please?
Certainly.
I agree with my colleague, Taran, that the municipality is really sparse with information on detail. So let me start first by asking whether the termination of Ms. Ndabeni's employment was by the effluxion of time as her contract, fixed-term contract, came to an end. Is that how her contract, her employment terminated?
It's difficult to tell on the papers what exactly the circumstances were.
So we don't know.
We don't know. It seems that either it could have been termination of one of the fixed terms of the contract that had been extended, or that she could have been transferred to and taken up employment with the provincial department.
Coming to the transfer, it seems, again, we don't know as a fact, it seems as though she has not been transferred because she claims to be unemployed, and that's not contested. If she was transferred, why is she unemployed? Or was she transferred?
It's not apparent. It's not apparent on the papers.
So another non-disclosure of material information. Then we go third to the materials that were before Mjali J. On the basis of the materials before Mjali J, which did not include the letters you now refer us to that surfaced in the contempt application in the reply. So exclusively on the materials before her, why could the judge have come to any other conclusion but the one that she did?
We would submit that the content of Section 66 ought to have been drawn to her attention in those proceedings,
Well,
and that if one is making an order in these circumstances, and one has Section 66 open and next to one in making the order, it raised glaring questions that required to be answered before an order of that nature was made.
Well, it seems so cut and dried. I mean, the answer really lies in Section 66. And the reason for the municipality not continuing to employ Ms. Ndabeni lies in Section 66. If the answer was so simple, why did the municipality fail to oppose the application? And I'm not referring to the explanation that comes subsequently about the audit period for about 4 months. I'm referring to the period from the time the application or the answering affidavits fell due in 2015. There's no explanation for that delay, is there?
I don't seek to defend the dilatory conduct of the municipality in these proceedings.
Well, I raise all these questions because it goes to mala fides, in my view. And I want to ask whether there's any connection between this evidence and the responsibility of the municipality under the Constitution, particularly Section 195, and there are other sections about compliance with the constitutional obligations. Is there a connection between constitutional obligations and mala fides?
I would submit that there is a component of the factual matrix that is important in that regard, and that is perhaps two components. The municipality was dilatory. We don't in any way seek to contend otherwise, but what is apparent from the documentation that is put up, and particularly the documentation that was put up attached to the reply from the petition to the SCA, they repeatedly raised the problem in relation to Section 66. And if the court wants me to, I can give the references to that right from the beginning. In their own affidavits, they concede that. The point was made over and over again. The ultimate failure to pursue the appeal before the Constitutional Court, before this court, was a failure of counsel. And that's uncontested on the papers. Counsel were briefed to prepare an application for leave to appeal to the Constitutional Court, and counsel failed to do so. So in that respect, the ultimate failure to appeal, a finger cannot be pointed at the municipality as far as that is concerned. Yes, they were dilatory, but they delayed in taking those steps. And in those circumstances, I would respectfully submit that it doesn't go to mala fides. It goes to dilatoriness, but it doesn't go to mala fides. And the attitude in relation to Section 66 is not something that was thought up at the stage that they were faced with contempt proceedings. What the documents do show is that they attempted to erase it. In fact, it's not expressly referred to, but it's implicitly referred to in the application to Justice Mjali for leave to appeal. It's referred to in detail in the petition to the Supreme Court of Appeal.
Sorry, Mr. Dodson. This dilatoriness didn't start when the appeal to the Constitutional Court fell due. It started when the answering affidavit fell due. And the answering affidavit in the proceedings before Mjali, instead of that, we had a Section 30 irregular proceeding application. And we had an adjournment, when the answer, as you quite correctly point out, lay very clearly, and it had it at its fingertips. Section 66. Why was that not resorted to? And there is no explanation for that. But coming back to blaming counsel, by the time that the application to this court fell due, Tassima was already in the public arena. And Tassima says that even if there's been a delay in bringing an application to set aside an invalid order, the court will consider it. And the delay is not as extreme as some of the other cases that the court has had to deal with. But that application was not brought. Instead, a resolution or a decision is taken to abide by the Mjali order, and it's still not complied with. There's no explanation for that.
I'm not sure that it's on the record that a resolution was taken
A decision was made. Well, it's on the papers. Yes.
Well, the thought process is described by the municipal manager, and with respect, it's an appropriate one. He realizes that as a result of council's failure the appeal has not gone ahead in the Constitutional Court. It's too late. He then says, I looked at whether or not we couldn't comply with the order. And he said, when he looked at it, I bumped into Section 60. I bumped into, once again, as he had said repeatedly before, I once again bumped heads with Section 66. And it creates a real difficult for him. It creates potential personal liability on his part in a very large sum of money.
And isn't that when he woke up to the reality of his non-compliance and unconstitutional conduct, when it was going to hit his pocket?
We would submit that not unconstitutional insofar as Section 66 is concerned. We would submit that he was doing what the statute required of him, which was to insist that there had to be a post before he could pay somebody and go through the acceptance of a contract in that position.
And then the non-disclosure of material information, first before Mjali by opposing the application properly, and in this court to date. Is that something that we should consider through the lens of 195, the duty to be accountable and transparent? You're not, your client is not.
With respect, there's no non-disclosure in these proceedings. These proceedings are confined to of necessity confined to the record in the High Court. And it would be impermissible for the municipality to seek to introduce new evidence in these proceedings to try and bolster its position.
And lastly, the state capture judgment makes it quite clear, and judgments before that, the issue of contempt is a matter between the court and the contemno. So why would it be relevant whether, well, it would have been helpful, but the fact that Ms. Ndabeni settled for the res judicata basis for, and the striking off position, and didn't pursue a substantive opposition, why would that be binding on this court?
I beg your pardon, Justice, but I just didn't follow the last question. I'm terribly sorry.
Okay, let me try that again. Ms. Ndabeni settled for a striking off of parts of the application. Yes, that's in the contempt application, and Griffiths J said that this was not a matter of res judica, and there wasn't a follow-up with a substantive defense. The fact that there wasn't, Ms. Ndabeni didn't follow up with a substantive defense of the judgment. Why is that binding on us? Because this is a matter, contempt is a matter between the court and the contemno.
Well, it seems to me that the ordinary rules in relation to how one deals with disputes of fact still apply in this court in relation to the contempt proceedings. And those would give the applicants, the municipality and the municipal manager, the benefit of the Plascon evidence rule. It would give them the benefit of the fact that she chose not to plead over in relation to the facts that they put up in relation to the staff establishment. And this court has accepted Plascon evidence as being part of its makeup. This court in the Helen Suzman Foundation case said that a party must plead over when they bring a strikeout application, which she didn't do. And so in the contempt proceedings, she should have the benefit of those mechanisms for analyzing evidence. Sorry, I beg your pardon, the applicants should have the benefit of those mechanisms for the analysis of evidence.
Yeah, sorry, I have one more question, and that relates to the remedy. If we were to find that the late Mr. Schlazer was acted mala fide Obviously, it's an order that we can't enforce because he is late. But there would have been other officials responsible or co-responsible, even though the buck stopped with Mr. Schlazer, but we don't know who they are. So in the circumstances, what would be the appropriate remedy if we were to find that there is contempt and that there is mala fide?
Well, it would seem to me that if it's directed at the late Mr. Schlazer, that is no longer open to the court because he's passed away.
Mm-hmm.
And the responsibility in relation to carrying out the order, it seems to me, focused on him. I don't immediately recall the division of obligations in terms of the order, but anything based on the contempt application that was directed at him, we would submit can effectively no longer be imposed on him.
So what's the remedy?
Well, obviously, we're asking that the judgment of Mr. Griffiths originally be upheld, and effectively that the appeal dismissed, and we would submit that that is the correct remedy. But if you're asking me what is the remedy that should be sought by my opponent, that's something I'd need to give thought to, and I'd need to have a look at the notice of motion to see to what extent it survives the death of the municipal manager. I don't have an immediate answer to that. Perhaps my learned friend is best placed to deal with that, and I can perhaps deal with it in reply.
Shouldn't Ms. Ndabeni at least have all her costs covered on some punitive basis?
We certainly, if we succeed, don't ask for costs against her. But if we fail, then certainly she would be entitled to her costs. And I would submit that in relation, I would submit that in relation to, it's a matter in the court's discretion ultimately. It may well be that there is a case for punitive costs. The conduct of the municipality, however, in relation to these proceedings in the Constitutional Court have not been in any way such as to deserve a punitive order of costs. They conducted themselves properly before the Constitutional Court. And as I recall, if the Supreme Court of Appeal judgment is to stand, I think there may well have been a punitive costs order from the Supreme Court of Appeal. So if we're unsuccessful, I think she's protected in respect of the proceedings in the Supreme Court of Appeal. And I would submit that in relation to the proceedings in the Constitutional Court, an ordinary costs order would be more appropriate, given that there's no conduct specific to these proceedings in respect of which criticism can be directed in terms of the conduct of the litigation at the municipality or the municipal manager.
Well, the unfortunate part of any cost order is that it doesn't come from the pocket of the contemnor, but from all our pockets at the end of the day. Thank you, Justice Madlanga.
Thank you, my sister.
Mr. Dodson, you accept that there is a statutory provision that was that prevented the municipality to act. That is section 66.3. You also say that they could not pursue the application for leave to appeal as a result of delays or inaction on the part of council. What I'd like to know is, once the municipal manager became aware of the impediment that is set out in the Municipal Systems Act, why was it not possible for the municipality to pursue the route of a rescission application? We know that the order was granted in the municipality's absence, of course, due to their own conduct in failing to comply with the date for filing of the answering affidavit. Was it open for them to apply for rescission, bring this particular provision to the attention of the court?
I think that the municipality would originally have had an election as to whether they apply for rescission or whether they pursue the avenue of appeal. I think that having pursued abortively the avenue of appeal, if at that late stage they had attempted to achieve the same outcome through a rescission application, I doubt very much whether it would have had any prospects of success. I don't know what the decision making in that regard was, but I think there would have been a tremendous delay that had to be explained at the end of that process. And the High Court would have been faced with, the High Court, considering the rescission application, would have been faced with the reality that would have been pertinently drawn to the attention of the High Court in the answering affidavit, that this entire process had been pursued as far as it could with an attempt to appeal to the Constitutional Court, and it had been done unsuccessfully. That would have included an order in which the Supreme Court of Appeal had looked at what had been put up in relation to Section 66 and had declined to grant leave to appeal. So a long way of saying I don't think there was any realistic prospect of a rescission application succeeding at that late stage in the day.
Okay. Now, insofar as the appeal that was before the SCA, what was before the SCA was the contempt application, the appeal on that. And yet the SCA interfered with the order of Mjali J. Was it competent on the SCA to do that?
No, it wasn't competent for the SCA to do that. What they were entitled to do was to treat it as a nullity in the way that an order was treated as a nullity in cases like Mutala. And that was certainly open, but to amend the order in the way that the majority did was not open to them. The matter in the contempt proceedings, that original judgment wasn't on appeal, as it were. The original order of Njali J wasn't on appeal, and therefore the Supreme Court of Appeal didn't have the power to amend or vary or set aside that particular order. And similarly, the criticism of Justice Griffiths in that regard was also inappropriate.
And if we don't agree with Justice Griffiths' conclusion that the order was a nullity, we say that the order is valid until set aside. What then?
Well, we would submit that a case has still been made out for there not to be a finding of contempt against the late Mr. Hlazo, and we say that the appeal should, in that respect, still be upheld. And our submission is based on the fact that enough facts have been put up to demonstrate that, in fact, the order was indeed a nullity. But if the court is against us in that regard, then obviously in these proceedings, relief must be granted as contemplated in the component of the notice of motion that dealt with the lawfulness question.
That is, if we are with you on the contempt leg of the order. Do we
Yes.
have to say anything on the judgment, an indication that there is a problem with the order, or what? I'm just trying to, what if Ms. Ndabeni decides again to say you must comply because the order is valid until set aside? What would happen?
Well, if the court was for us, one would be able to refer to the fact that the court in its reasoning held that the order was in fact a nullity. And if one looks at the way that, for example, in Knoop, the judgment of the Supreme Court of Appeal deals with Mutala type orders, that is sufficient, we would submit, to that is sufficient to address the difficulty that is faced. And if she tried to recommence the proceedings, one would then obviously introduce the finding of Justice Griffiths, which had been upheld by the Constitutional Court, to say that there was a finding of nullity of the order. So even though it doesn't appear in the relief, it is an instance in which its appearance and its finding in the reasoning would be a sufficient protection.
Thank you, Justice Madlanga. Thank you, Mr. Johnson.
Could I ask a follow-up question there, please, Justice Madlanga? Just on the question of the remedy, the order, of course, Mr. Dodson, was sought for contempt against the municipal manager personally. If you look at the notice of motion, he was asked, the late Mr. Schlauser himself, well, obviously in his capacity as municipal manager, he himself was asked to show cause why he shouldn't be declared in contempt of the court order. Is that correct?
If you'll bear with me, Justice Majita, I'm just looking at the order quickly to.
Well, I started with a notice of motion. What was asked from the High Court was an order that he must show cause, Mr. Mhlauzo personally, first respondent must show cause.
Indeed.
That's at page 2. Then, if I could then go to the judgment delivered by Griffiths J. That's in the same volume, and that was volume 1. It seems to me at some stage, Ndabeni abandoned criminal sanction. Am I right? Before that.
Indeed, that was before Justice Griffiths. Yes.
Yes. But what was sought, because of course this was the return day, what was sought was still civil sanction. In other words, an order compelling Mr. Clauser and the municipality to comply with the order from Charlie J. Am I right?
Yes.
Yes. I just wanted to clear that up. Thank you, Justice.
Sorry, Mr. Dodson. Oh.
Justice Madondo?
Yes, but that I'm having a problem, but if you can hear me.
I can hear you loud and clear, Justice Madondo.
You will correct me if I'm wrong. My understanding is that the resolution came first before the order.
Indeed.
Yes. And at the time, Mr. Ndabeni was also a contract employee.
Indeed.
So was this resolution also intended to apply to her as well, like all other employees who were in contract?
If we look, we can look at the resolution. It was put up by the respondent in these proceedings, even though it wasn't part of the earlier. But if one looks at that appears at page 299. It seems that page 299 of the record.
What does 299 say?
It says that the additional employees on contract and those who are on political offices not on the attached list be converted to permanent employees subject to confirmation by the local labor forum be approved. And what we can piece together from the evidence that is available is that it seems that she fell under that paragraph initially, but that her position was shifted to the Eastern Cape Department of Health.
Okay, so now she was supposed also to be translated, or her post was supposed to be translated like all others, into a permanent one.
That at the time of the resolution, it seems to have been the case, subject to confirmation by the local labour forum.
So why was she discriminated against? Because according to all other employees who were in the same position as she, their posts were converted, and only her who was discriminated against.
It appears from the available evidence that her position was, as they described it, provincialized. In other words, certainly the municipality's contention was that the Eastern Cape Department of Health became responsible for her as employer.
But I see that she was notified of this change by the employer. If that was the case, why she was notified? That will also occur to her.
I'm sorry, I didn't hear you on the last question, Justice Matondo.
The last question is that Judge Mjali referred to the notice she received. That should also be, her post will also be converted into a permanent one.
It's likely, if one looks at what happened on the available evidence,
then she was not in the list of the people. Why was she informed? Yes.
My understanding is that she, if one looks at the letter that I referred the court to, she says she went and asked, and she found out that her name was not on the list, and her name not being on the list seemed to put her into this category C. So I am not sure whether it's appropriate to find, on the basis of what was in her original, in her founding affidavit, that she was notified, or whether one must look at what the available evidence tells us, including the letter under her own hand, in which she said she was informed that her name was not on this list, which would seem to have rendered it initially at least subject to approval by the local labour forum. And later, her letter also suggests to us that her employer became the Eastern Cape Department of Health, or at least that was the contention of the municipality.
But is there anything concerning her evidence that she was informed, like all others?
Well, no answering affidavit was, if the allegation was contained in the original founding affidavit, then no answering affidavit was filed in those proceedings. I don't recall, and it may well be there. I don't recall seeing that in the founding affidavit in these proceedings, but it may well be there.
Which will mean that in this regard, her allegations remain undisputed.
Well, if that is what flows from the, and I just don't have I don't have a recollection of what is in the record in these proceedings. If she says in these proceedings that that she was notified like everybody else, and if we look at the answering affidavit and that isn't disputed, then I must concede that. But I just haven't done that. I don't have that analysis readily to hand.
So in this, in the premises, will I be correct to say the provisions of 66, section 66 is just a mere red herring?
With respect, I would submit not. If the contract for which she contends was to be valid, it had to be valid when tested against section 66.
Well, the section 66 was considered after, when she took the matter up. That was not the first consideration at all at the time when the resolution was made.
Well, that may be so, but it doesn't change the objective fact that the resolution, until such time as there was a position on the staff establishment, the resolution would have been invalid without even the need to declare it as such. The resolution would have been invalid to that extent in terms of section 66 and 66.4 in particular.
So wouldn't it be appropriate to say to her, look, you don't fall under this category, even though we say all the contract employees, but you are excluded. There's nothing to that effect. This came after she had taken the matter up to court.
Well, that's essentially what happens is once the matter gets to court, the parties scrutinize the legality of the process, and the scrutiny process, late as it came here, although it was raised already in the petition to the Supreme Court of Appeal, the scrutiny process we submit shows that the order does not pass muster.
And try to find all the leeways can possibly find.
Well, we submit that the question of section 66 is a serious one and is seriously raised and needs to be considered, Justice Matondo, with respect.
Because now with serious at the end, the one would expect it to be serious right from the outset.
Well, it was raised at the point where the participation started. So it was raised impliedly in the application for leave to appeal that was made to Justice Mjali, and it was then raised expressly in the petition to the Supreme Court of Appeal.
Well, that was too late. That should have been considered at the time when the resolution was made and applied.
Indeed, I would accept that that should have taken place, Justice Matondo.
Okay, thank you, Justice Mandlanga.
Thank you, my brother. Mr. Dodson, still want more time? So if so, how much?
No, I think that in the course of the questions, I probably canvassed what I needed to canvass. Thank you, Justice Matlanga. We'd obviously, in terms of what we seek, we'd ask for condonation of the late filing of the record, that leave to appeal be granted, and that the order of the Supreme Court is set aside in its entirety and replaced with an order saying the appeal is dismissed with no order as to costs.
Thank you, Mr. Dodson. Mr. What's the time now? I think, colleagues, we should let's take a break and just come back at 11:45, colleagues. Quarter, Jen?
Court will adjourn until 11:45. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences. Should you exit, you may use the same link to rejoin the hearing.
It is 1:45. Are we not? Is Justice Madondo? Or thank you. I think we're all back.
Justice Madlanga and justices, all counsel are online.
Thank you. Yes, Mr. Maleka.
Justice Madlanga. Switch off. Justice Madlanga, I hope you can hear me.
Yes, loud and clear. Thank you. Thank you, Mr. Maleka.
I will not take the fifth. I would welcome such questions as the court may have immediately, because I consider it my duty to help the court than to repeat our argument.
Thank you. Thank you, Mr. Maleka.
We have prepared full and detailed heads of argument, where some of the questions which the court raised with our learned friends have been dealt with. Subject to the questions from the court, what I propose to do is to set the scene in order to perforce add some submissions in regard to the concerns the court has raised with our learned friends. The first issue I would like to raise by setting the scene is that in the concluding part of their submissions, our learned friends asked the court to apply the Mutala judgment and therefore uphold the order which was issued by Griffith J. We would like to ask the court to turn to the order which Justice Griffiths issued. And you will find it in volume 2, sorry. Is it volume 1? No? My apologies, it's volume 1. At page 78. And there you'll see that the only order which the learned judge gave was simply to discharge the rule that was issued by Mbenenge JP on the 19th of February 2019. That's the sum total of the order made by the learned judge, despite the fact that he had concluded that the previous order of Justice Mjali was a nullity. We would submit that that order itself does not bring the applicants within the remit of the Mutala principle, because Mutala made it quite clear that the mere conclusion of a nullity is not enough. The court must go further and set aside the judgment which gave rise to the order that is said to be a nullity. I ask the court in that regard to bear in mind the introductory paragraph of the Mutala judgment, where the court made it quite clear that the order which was previously issued by Kruger AJ should and was set aside. The remarkable feature of the present application and appeal is that there has not been any quest by the applicants throughout this long litigation where they sought to set aside the Mjali J's order. We submit that that is fundamentally important, because even on their approach, the present appeal should fail, because as
in that case, Mr. Maleka, Ms. Ndabeni should not have gone to the SCA either, or who went there?
It is Miss Ndabeni who went to the
Yes. Then on that argument, she shouldn't have gone there. She should have just said, the order granted in my favor by Mjali J stands. So, and that's it, or not?
Well, no, not with respect, because what those proceedings before the ACA were concerned with was the multiplicity of relief sought beyond the mere fact of the declaration. There was also a contempt aspect that he sought, and that was an issue also before the SCA, so that she was entitled to go to the SCA in order to oppose also that part of the debate arising from the rule Nisi issued by Mbenenge JP. So we would submit that until our learned friends ask this court to set aside the Mjali J's order, it doesn't help them to submit that the judgment of the SCA was wrong. The next point that I'd like to raise by setting the scene is the conduct of the applicants. I raise this issue in the light of a number of questions which have been put to our learned friends for the applicants around the conduct of the municipality, around non-disclosure, and the failure to set aside their own resolution. We would ask the court to go to the very volume 1, and at page 36, paragraph 28, you will see that there the applicants, in their opposing affidavit, resisting an order to declare them contemptuous, they make it quite clear that they abandoned a further approach to this court after the Supreme Court of Appeal had dismissed their application for leave to appeal against the judgment of Mjali J. You would recall, Justice Madlanga, that the Supreme Court dismissed the application for leave to appeal on the 30th of July, 2018. And what the applicants say here is that they abandoned the further approach to this court because they considered that there was some unreasonable delay. To a question raised by a member of the bench about whether or not the applicants should not have sought a rescission, our learned friends seem to have suggested, if we understood their answer, that the applicants had a choice either to proceed with an appeal or to proceed with some other form of reactive challenge, including a rescission. We would submit that in the context of the facts of this case, there was no option open to the applicant to pursue either an appeal or some other reactive challenge. There was a duty placed upon the applicants to bring a reactive challenge, even if it was by way of a collateral challenge, in order to seek, firstly, the review and setting aside of its own resolution around which certain rights and benefits were conferred upon Ms. Mjali. Secondly, they could not ignore the judgment and order of Justice Mjali based on their own choosing, for as long as they believed that their judgment was based on a nullity. And therefore, we would submit that this court should find that there was no option at all. Even if they were to proceed with an appeal, they were duty bound to seek a self-review of their own decision and to seek a rescission of the order by Justice Njali. These are the elementary principles arising from the judgments of this court from Kirland and Tumirafung. We would submit that when Justice Theron put to our learned friends the fulsome application of the Kirland and the Mirafung principle, it is no answer for learned friends to suggest that they were not obliged to respond by way of the Kirland principle simply because the nullity in question here arose by reason of the application of Section 66. This is not a mere matter of application of the law. It is application of the law with reference to the facts. The court has raised a number of factual issues, and our learned friend's response was that they could not clarify those factual questions for the benefit of the court. It is precisely because the applicants have chosen not to bring a rescission application where they had to deal with those facts. It is precisely because the applicants have not brought a self-review application to set aside their own resolutions. We are not surprised that the applicants have not brought an application for self-review and the setting aside of the resolution, because they made a clear election, as appears from that passage of the answering affidavit, and that is paragraph 28 of the answering affidavit, that they will comply with that order. It is also not an answer for our learned friends to suggest that the appeal consent would be mired in some contentions of delay. It is not for the applicants to avoid an appeal because of the delay. The question of the delay is a matter which this court would have decided, having regard to all the relevant facts. And we know that this court has even condoned a delay as much as 50 years after an administrative action that is sought to be impugned was taken. Now, the explanation given by the applicants that they were unable to comply with the court order is that there is a legal impediment created by Section 66.3 and 66.4. Justice Matlanga, you raised a number of problems relating to the applicant's case around whether or not their defense was raised before Mjali J when she gave that order. We would submit that you were correct when you raised that issue, because in paragraph 45, page 27 of our heads, we make it clear that there is a procedural hurdle which stood in the way of the applicant's contention in the proceedings before Griffiths J, because those issues were not raised in the proceedings before Mjali J. The first time those issues were raised was when the applicants applied for leave to appeal against the judgment and order of Mjali J on the merits of the respondent's application. May I give the court references where the issue was raised for the first time? It was raised for the first time as appears in volume 3, page 222, in paragraph 5.3. And that's the ground for application for leave to appeal raised in paragraph 5.3. And you will see that it is raised in general terms without reference to section 66, 3 and 4 in terms. Then Jali J dealt with that issue in her judgment refusing leave to appeal. You will find it in paragraph in volume 2, page 174, paragraphs 6 and 7. And we know that she refused the application for leave to appeal, and the SCA dismissed the attempt by the applicant to revive that issue. And so we would submit that by the time the SCA gave its judgment on the 30th of July 2018, that issue had been finally disposed of and the door was closed for the applicant. And therefore it is not surprising when they said in paragraph 28 in the proceedings before Justice Griffiths that they elected to implement the judgment of Jali J. You would recall that in our heads, we expressly make reference to the judgment of this court in Pretoria's case about state promise, which is actionable and enforceable. And the resolution of the council in this case represents that kind of a state promise to one of its own employees. And we submit that that promise is enforceable until the resolution has been properly challenged and set aside by this court. Justice Matlanga, the next point that I'd like to raise is this, that our learned prince suggests that the applicants were entitled to ignore the resolution because the resolution was in conflict with Section 66 of the Systems Act. We have dealt with that issue in paragraph 47 of our heads, and would like to emphasize 2 points in that regard, in addition to the fact that the resolution has not been challenged and therefore is still valid. The first is that it is the council of the second respondent and not the municipal manager who has the constitutional obligation reflected in Section 67 of the Systems Act to deal with matters relating to employment of its own employees. You recall that in our heads, we asked the court to consider the provisions of Section 67 of the Systems Act, which deals with the powers of council to formulate a human resource development relating to the recruitment, selection, and appointment of persons as staff members of the council. So the primary power vests in council. It is not surprising that in this case, council of its own accord decided to adopt Resolution 1011. It did so in terms of the powers vested upon it in terms of Section 67. And it was a developmental human resource action by council to elevate and promote temporary employees into permanent staff members. One of the difficulties which the applicants face, and we would respectfully submit, they have not dealt with that issue arising from the questions put to them by Justice Madondo and also Justice Majid, is the fact that immediately after the adoption of that resolution, members of its own staff members who were temporary employees and in fact subordinates of Ms. Ndabeni were elevated into permanent positions. And they have not explained at all why was the respondent left behind. There are two consequences to the attitude adopted by the applicants in that case. The first is that they implemented the resolution, regardless of the purported impediment created by Section 66(3). So that on the facts, it is not an answer to Ms. Ndabeni's case to suggest that there is an impediment. They did so. There is lack of explanation why the applicants were able to implement the resolution on the one hand, and they flatly refused to implement it in regard to Ms. Ndabeni.
Mr. Maleka, may I raise something, an aspect that concerns me about the question of on the contempt issue, and that is mala fides. It's clear that the majority misread the affidavit, the answering affidavit of, I think Mr. Hlazo is the one who proposed to it, which at its introduction, it says, this is a denial of the following. And then the court unfortunately read it as an admission.
Yes.
Now that particular misreading has a direct impact on the question of mala fides and willfulness for the contempt, because in PECO, this court said that an honest belief, even if mistaken, that there is a justification for non-compliance does not accord with the intent necessary to find intent for the purposes of contempt of court. Now, what bothers me is that, firstly, that misreading has some impact, but the major aspect that bothers me is that here we have the MM, the municipal manager, and the council being advised by Silk, and Silk advises them of the legal position, and they accept that honestly. And on that basis, they say to the SCA, well, they say in the answering affidavit, sorry, misread by the SCA, that it was never our intention to willfully disregard that court order. We deny that that is the case, and we say we acted in the mistaken, in the honest belief that counsel is right in the advice. So have they not discharged that evidentiary burden? And if so, then where does that leave us?
Justice Majid, let me immediately say that you're correct, that the SCA omitted to reference the preamble to paragraph 20, which makes it quite clear that the passage the SCA lifted in its judgment was a denial and not an admission. But to your question, the propositions you've put to me make it even a case of mana fide much more stronger against the applicants. The starting point is that they rely on the advice of their counsel. There are judgments of the Supreme Court, and I'm not going to take the court to them, that where you rely on the legal advice, you must make it quite clear that the legal advice is not a legal advice which no reasonable lawyer can give. I will not get to that point. I will ask the court to assume that the advice given was a reasonable advice. The difficulty with the legal advice given is that it does not reflect on the gateway to the application by Ms. Ndabeni. And the gateway we know is the resolution of council. That resolution remains valid. That resolution ought to be implemented by the municipal manager unless it was set aside. Secondly, to the extent that the applicants believed that section 66, 3 and 4 were the impediments. They were obliged. They had no option. They were obliged to self-review the resolution. They were also obliged to seek a rescission of the Mjalije's order. The entire opposing affidavit raising those issues around legal advice is entirely silent on those two matters. There is a fundamental failure by the applicants to deal with the legal status and effect of the resolution. There is an entire silence about why they did not approach the court for rescission, where all of those matters would have been raised, and they would have been obliged to disclose the nature and extent of the legal advice, and Ms. Ndabeni would have been entitled to deal with it. So we would submit that there is a case of clear bad faith on their part, in addition to failure to disclose all the matters which Justice Pillay raised with them. The third point I'd like to make in relation to mana fides is the case of the applicant where, on the one hand, they oppose Ms. Ndabeni's initial application, and when she succeeded ultimately in the SCA in round 1, they elect to implement the resolution of council. It is quite clear on the passage that I've read to the court in their opposing affidavit in round 2 that they elected voluntarily to implement the court order. What follows thereafter is a version of the municipal manager and not the version of council that when he sought to implement that court order, he was confronted by section 66 impediments. But there is no explanation why he did not go to council and say, what do we do with reference to your resolution? Because that resolution poses difficulties for me. And we would submit that the absence of an explanation in that regard and the mere invocation of 66 as a bar to the implementation of the court order is a manifestation of bad faith in that regard. So that we would submit that on all scores, the case of bad faith is the one that has not been displaced by the applicants. Justice Majid, I believe that I have answered your question.
Yes, thank you. Thank you. But that brings me to the question then, which was also raised when Mr. Dodson was arguing, what relief should this court grant now that Mr. Tlazo regrettably has passed away? Yes. And I thought the order was against him for contempt personally. Although I think in the application, you correct me if I'm wrong, but in the application, Ms. Ndabeni asked that, of course, the orders of Mjali be complied with regard to payment of the salary prospectively and retrospectively. Yes. So what relief should then follow?
Justice Majid, can I take you to page 161, volume 2? And you'll see that the SCA made the following substituted order. And I ask you to consider paragraph C of the main paragraph 2 of that order. The respondents are ordered to purge the aforesaid contempt within 30 days of the date of that order. So we would respectfully submit that although Mr. What's the name?
Tlazo
has passed on, the office that he occupied that gave rise to the allegations of impediment is still there, and his successor would be bound by reason of the office he or she occupies to purge the contempt within a period of 30 days. And we would therefore support that order of the majority of the SCA.
Can I just move to another oddity, lastly from my side, which is, or not another oddity, an oddity which is another point altogether. And that is that, curiously, and while we're at volume 2, in the judgment of the SCA majority, what I found quite curious is that the court proceeded to interrogate the order of Njali J, notwithstanding what was before it was the order of Griffith J. And that's at page 160 at paragraph 24 of that same volume, just a few pages back. Actually, just the previous page. The court says it's the final issue to consider is whether this court should confirm the Njali J's order in its entirety without falling foul of usurping a power that it does not have. And ironically, it seems to me that the court was home to Sofikio by this time, not so?
Yes.
As regards that order. But this is the intriguing part. If you just continue, it finds no fault with paragraphs 1, 4, and 5 of the order. But it says, insofar as paragraph 2 is concerned, different considerations apply. In my view, the terms of paragraph 2 are overbroad to the extent that they in effect create a permanent post in the second respondent staff establishment, when the power to do so is an exclusive preserver of municipal council. And of course, you've pointed out to section 67 of the Systems Act, read with section 66, which is related to it. That seems to suggest that the court is aware of the fact that a court can't create a permanent post, only the municipal council can, which seems to bolster the argument put up by the applicants here. I just convey it to you for what it's worth, that portion of it. Yeah. What do you say about that?
Justice Majid, you're quite correct. And I'd like you to reflect on your views in that regard in the context of what Justice Rogers said. The difficulty with that part of the conclusion of the majority is that it ignores that on the fact the post for permanent employment had already been created by council itself. It was not as if when Njali J made the declaration, he or she was creating the post. The post for permanency had already been declared in terms of the resolution of council. But secondly, the order given by Njali J was no more than declaratory and not creative as Justice Rogers had created. Our learned friend takes issue with the terms of the order. We don't understand why he would do so. We have quoted that order on page 3, footnote 2 of our heads. And you'll see that from the quotation we made, paragraph 2 is declaratory in terms. It does not create a post. Not only did the learned judge issue the declaration relating to permanency, but she referenced the declaration to resolution 1011 of the Municipal Council, so that we would submit that whilst the SCA was cautious in paragraph 24, there was no need for it to be cautious as it did.
Yes, thank you.
Whilst on the score, Justice Majid, can I ask you to also reflect on what the majority concluded with regards to the conduct of the applicants in regards to their failure to deal with and explain the status of the resolution? The SCA had some serious remark to make about that conduct, and it is at volume 2, page 156, paragraphs 16 and 17. I'm not going to read them. I merely ask the court to take that into account as yet another manifestation of bad faith. So that we would submit that in sum, the application for leave to appeal should be dismissed with costs. And we would submit that a special cost order on a 10-inclined scale is justified in this case. It is the municipal council which is engaged in relentless litigation against one of its employees. You know as a fact that Ms. Ndabeni is no more than an ordinary employee, not possessed of substantial financial muscle to keep on fighting counsel in this case. We know that counsel has a constitutional duty reflected in the provision of section 195, but also in section 237 of the Constitution. There is no suggestion at all that the resolution was taken.
Through you, sorry to interrupt you, Mr. Malika. My question relates to the punitive nature of the court order you're seeking. Does it matter that Mr. Hlazo has now passed on? And also the fact that if the second appellant were to be ordered to pay punitive costs, that would come out of the public purse?
We on the first issue, we submit that it matters not that Mr. Hlazo has passed on for the court to properly exercise its discretion on the punitive nature of the court order. We contend for, because as I've said, Mr. Hlazo occupies an official position, and he sought to rely on the provisions of section 66 in order to purportedly discharge his function. On the second issue, around the question of public funds, we accept that the court would be reluctant to impose costs order of a punitive nature, which would ultimately have to be borne by the public purse. But we ask the court to consider the exceptional nature of this case. I have already pointed out to two critical exceptional nature of the case, where this case, unlike previous other cases of contempt, there is not any form of reactive challenge in order to resist Justice Chikwe, I think I have some competition from my junior with iPad 65.
I trust that he has muted himself, Mr. Maleka.
Yes, it has now been muted. The point I sought to make, Justice Chikwe, in addition to the exceptional nature of this case, is that this is a case which is fundamentally different to other cases of contempt. For instance, the Tazima case, there we know that the Department of Transport brought a reactive challenge by means of a counter application to set aside the contract which gave rise to the contempt orders. And we know that this court upheld those parts of the contempt orders which were issued during the subsistence of the extended contract. But once the extended contract came to an end, the court discharged the contempt orders because there was no longer a pre-existing contract which could give rise to non-compliance. Also in the Merafung case, we know that there was a reactive challenge of some sort. In this case, there is no reactive challenge whatsoever. And the applicants believe that they're entitled to ignore their own resolution with impunity. And we would submit that that fact in itself is something the court would have regard in exercising its discretion to impose a special cost order, even though it will come from the public purse. The final point we would like to make in this regard is this, that you are dealing with a litigant who is an ordinary litigant, a ratepayer, and an employee of the very council. Council has sought to relentlessly oppose the attempt by Ms. Ndabeni to right the wrong it has created. There was no basis in the beginning to do so. And whilst we are sympathetic to the fact that the cost we contend for will come from the public purse, this is a case where it would be justified. And if there are consequences, then the Auditor General will deal with it in due course.
Thank you, Justice Madanga.
Thank you. Thank you, my sister. Mr. Maleka, are those your submissions?
Those are submissions, Justice Madanga.
Thank you very much. Mr. Dodson?
Sorry, Justice Madlanga, just 1 or 2 points for clarification. Thank you, Mr. Maleka. So the Njali order, Njali J order, you would say is a valid order?
Indeed, it's a valid order we would submit.
And would you draw any distinction, assuming that it was not valid, between a valid, invalid, or order or a nullity?
We would submit that even if it was an invalid order, it will still produce legal consequences until it is properly set aside by a court of competent jurisdiction.
Mm-hmm. And is it your case that the defense raised based on Section 66, is that an afterthought or was that a position from the beginning?
We make it quite clear in our heads, Justice Pillay, that it was an afterthought opportunistically raised for the first time when the application for contempt was brought. If it was a defense genuinely held, it should have been raised by the council itself, proactively taking legal proceedings to set aside all the rights and benefits which bring about the purported impediment they rely on. It is one of those funny cases where the council sits upon its laurels and does not take any action whatsoever to proactively correct the defects it claims it has created by reason of the resolution. Instead, at every day, it responds to litigation brought by a litigant such as Ms. Ndabeni, who we know is just an ordinary employee, not possessed of funds to fight all these difficult cases.
And should one have regard to Section 195, 235, and I think it is 156 of the Constitution in assessing whether there was mala fides?
Indeed, indeed. And in this case, we would submit that those norms of a professional public service provided for in Section 195 apply with greater force. You would recall that in Merafong, I think, and also in the Tasima judgment of the Supreme Court of Appeal, the courts have emphasized that the municipality, just as any other organ of state, has a greater obligation than ordinary litigants to live up to and fulfill constitutional obligations. And we have referenced Section 237, even though neither Justice Njali and the SCA refer to it, simply to make the point that Section 237 imposes a duty on the municipality to fulfill its constitutional obligation diligently and without delay. The moment they concluded, with the advice of their lawyers, that there was a legal impediment, they had no choice, but they had to go to court diligently and urgently, and they failed to do so.
Thank you, Justice Madlanga.
Oh, thank you, my sister, and thank you again, Mr. Maleka. Mr. Dodson? You are muted, Mr. Dodson.
I beg your pardon. I'll start again. To respond to the contention that the judgment of His Lordship Mr. Justice Griffiths ought to have included a provision setting aside the order of Mjali J, we would submit that that wouldn't have been competent for him to do, and the Mutala judgment is no authority for him having borne an obligation to do that. If one looks at the Mutala judgment, in the order that it made, all that it did is to set aside the finding of contempt, nothing more. The question of nullity is dealt with in the reasoning in the judgment, and in particular at paragraph 14. So no criticism can be addressed at Justice Griffiths for not having set aside the Mjali J order. In fact, he had no jurisdiction to do so. It wasn't in that sense before him on appeal or in any way where he was entitled to reconsider that order. But Mutala was indeed authority for his entitlement in his reasoning process, as he did, to reach the conclusion that the order was a nullity. Then to deal with the issue of the appointment in terms of section 67, sorry, the resolution having been made in terms of section 67. Again, we say that is a further and strong indication of non-compliance of the resolution with section 66. In fact, if it was made in terms of section 67, it was made without authority. And if one looks at what section 67 does, it deals with systems and procedures. If I can give the exact wording, it deals with system, the heading is human resource development, and it deals with the development and adoption of appropriate systems and procedures for fair, efficient, effective, and transparent personnel administration. It nowhere, in fact, gives a distinct power of recruitment. It nowhere provides for the bypassing of section 66. And if, as is submitted, the resolution was passed in terms of section 67, that is a further basis upon which the resolution was flawed and unlawful. We submit that in response to the contention that there was an obligation to self-review, firstly, these developments took place at a time where the law itself was, they took place several years ago, at a time when the law was developing in relation to self-review. We must remember that at one point it was open to question whether the state could indeed bring a collateral challenge or a reactive challenge to its own decisions. So one can't treat the matter on the basis that this has always been a part of our law. One certainly can't judge the conduct of Mr. Klaas, or for purposes of contempt, with reference to those developments in relation to the law. And in addition to that, we have the unusual and unique situation in section 66 that it expressly provides for nullity. I certainly have never come across a similar provision. And one must remember that if one goes back to Odekral, the Supreme Court of Appeal refers back to the presumption underlying what was ultimately its decision in that, and that is the presumption omnia praesimuntur rita esse acta. In other words, a presumption that everything is done validly. It is referred to again later in the judgment in more modern terms, but it essentially operates at the level of an assumption. And the effect here of introducing an express provision in section 66(4) for nullity is that it operates directly against that presumption. One can't assume that that presumption operates when the legislature has specifically said it will be null and void. And one can see why the legislature has done it if one looks at section 66, in particular section 66(5). What the legislature is saying is these commitments in relation to staff establishments and the employment of staff involve the expenditure of money from the public purse. And the legislature is saying strongly upfront and expressly in legislation, don't employ people where there is no position on the staff establishment. And if you do that, the state isn't going to pay for it. It's going to come out of the pocket of the municipal manager. So the important is a unique and important one. And it certainly operates to justify.
May I just ask a legal question, Mr. Dawson? Was the resolution 10 of 2011 policy? I think it was. Would you agree? It's a policy decision. Let us now stop, as a matter of policy, let us now stop having temporary employees and let's have them employed permanently.
It would seem to have been a policy provision because importantly, it had no deadline to it.
All right.
It didn't have immediate effect. It was something that was obviously going to be implemented over time.
Okay, okay, all right. Yes, let me listen. Yes.
No, I'm listening. I'm listening, Judge.
All right. Would that policy fall within the ambit of open quote policy framework close quote envisaged in section 66(1)?
With respect, no. Certainly not on the basis of what the applicants are, I beg your pardon, what the respondent is contending for. The respondent is contending that the effect of the policy was to give her an immediately enforceable right as a permanent employee of the council, and on top of that,
I'm not talking about it in relation to a specific employee. One, I established from you that it was policy. Now, just as a matter of objective legal principle, I want to know if you accept that that resolution would fall under the ambit of the policy framework envisaged in section 66(1). I'm not talking about Ms. Ndabeni.
I hadn't thought about that, and I needed a moment to consider it, Justice Madlanga. There's certainly no evidence to suggest that it was a policy framework as contemplated in section 66(1).
Not for other clerks, no.
I'm sorry, Justice Theron, please mute yourself.
My apologies.
Thank you.
There's an unknown person in the waiting room.
Thank you. Thank you. I would have thought do you think this is something that would require evidence? Because if you've accepted its policy, then is it not a matter of legal interpretation whether or not it is the sort of policy that would fall under the ambit of 66(1)? I would have thought it should be a legal question, not necessarily dependent on evidence.
My submission is it would be dependent on evidence because we just don't know whether it was intended as something that was made in terms of section 66(1). I'm assessing. I'm not doing it on the basis of an assessment of the facts. I'm doing it as a response to your question, trying to pin a label to it as a matter of law as to whether it was in the nature of a policy decision. And and my answers are of necessity in the absence of evidence to say that it was in terms of section 66(1). My answers are speculative. I think in a broad sense, it may be capable of characterizing it as policy, but there simply isn't a basis to know whether it was intended to be something for purposes of section 66(1).
Let me try this. So council has made the resolution. Based on that, the next step should be what is in paragraph A of section 66(1). The municipal manager would then have to tinker with the staff establishment that was existing prior to council resolving to make temporary employees permanent. The establishment would just have to be adjusted so as to cater for those employees. Otherwise, the resolution would be meaningless.
Indeed. In the absence of those posts having provided for in the staff establishment, the resolution would indeed be meaningless.
Yes. So I just don't see why it would not fall under that framework. Why that full policy would not fall under that framework.
Simply because my submission would be that one would need to know what the facts were. For me, if I look at specifically,
what more would you want to know?
Well, what seems to be envisaged there is that there is an overarching framework in terms of which the staff establishment is developed, an overarching policy framework. If your question to me was, is this a policy framework for purposes of establishing staff, then I would say no. When you ask me the question, is it a policy? I said in the general sense and of how one understands a policy, yes, it might be capable of being characterized as a policy. But certainly, I wouldn't give.
All right, maybe let me ask a different question then. So once the municipality had taken the resolution, it would have been something purely mechanical. First, for the municipality to then put in place a policy framework to cater for its own resolution. Otherwise, it would have been nonsensical for it to take the resolution in the first place. And then secondly, once the council had done that is put in place the policy framework envisaged in 66(1), again, it would be something mechanical for the municipal manager to then adjust the staff establishment as envisaged in 66(1)(a). Otherwise, the resolution would be meaningless. It wouldn't be worth the paper it was written on.
Well, it seems to me that one can't equate one certainly can't equate the resolution in this instance with the policy framework. And the policy framework, it seems to me, is something that must come first as an overarching document. That's the first step. Second step is for the municipal manager to develop a staff establishment within the policy framework that has been laid down by him. Once he has done that, it's then open, I would respectfully submit, for appointments to be made to those particular staff establishment positions that have been done. But certainly the policy, sorry, I beg your pardon, the resolution ought to have been something that came after the posts had been established, not before.
You may continue, Mr. Dodson.
Thank you.
Just on that aspect, Mr. Dodson, before you proceed, I understand on the facts of this case, the municipal manager already implemented the resolution of council, but for Ms. Ndabeni. But is it not one of the purposes of this section to give the municipal manager as the accounting officer to ensure that a proper policy resolution is taken and all what is required for its implementation is in place as the accounting officer?
So I think that the duty to establish a policy framework is something that rests on the council itself, on the municipal council itself. Once that is done, the responsibility then falls on the municipal manager to develop that staff establishment.
Do you have any authority to veto the resolution of the council?
Well, if the short answer is yes. If the council takes a resolution that appoints people into positions that don't exist on the staff establishment,
yes,
yes, he does have the entitlement to veto it, but in a way the work is already done for him by Section 66.4, because Section 66.4 says if they do that, it's null and void.
Yes, although he might have the veto powers, but what distinguishes this case is that already that resolution was being implemented, but for Ms. Ndabeni.
Yes, and we don't know. It may be that the staff establishment had been adapted for the other employees, and it hadn't been established, it hadn't been done as far as Ms. Ndabeni is concerned. But the facts certainly show that if one looks at that organogram, objectively, what is demonstrated in these proceedings is that there is no post on the staff establishment for the position contended for by Ms. Ndabeni. And perhaps I can just refer the court to the relevant page of the record. It's at page 224, if I remember correctly, which I think is in volume 3. One sees there at page 224 what the different positions are in the staff establishment that are the closest to where she could be. And what one finds is that there is a position of senior coordinator, HIV/AIDS and LM support. And then above that, there is a position manager social development. But none of those constitute attic manager. None of those constitute senior coordinator manager. And what is clear is that the only one that refers to HIV/AIDS is not a managerial position. If one looks at page 224, all of those positions occupy a level in the structure below the level of management. So on her own version, that cannot be her position.
I see.
So objectively, as far as she is concerned, whatever the position may be with the other employees, her position is not there. And also interestingly is none of the attic, there's no reference to any attic position, which would seem to lend credence to what is apparent from the correspondence, that the attic function was transferred across to the Eastern Cape Department of Health. If I can then...
if my brother's done, Mr. Dodson, the questions posed by Justice Madlanga in relation to Section 61 and the issues about policy, those issues were never before Mjali J, correct?
No, they weren't before Mjali J.
Never raised before her.
They weren't.
Okay. Yeah.
They weren't raised before her, but the submission that we make is when one saw what was being asked for by way of the order, and one can't blame her, but certainly counsel appearing for the municipality ought to have drawn her attention to Section 66 and have said why it was compliant, because it quite clearly, if one looks at that order, it quite clearly engages Section 66. It talks about staff being placed on the post, and it was incumbent upon council to show that there was a prima facie case. It was incumbent upon council in an unopposed case to demonstrate that and draw to her attention all components of the law, whether it helped or didn't help them. And Section 66 ought to have been drawn back. It was in a situation where it was effectively unopposed motion court. The opposition had fallen away, and that ought to have been drawn to her attention.
But no one better than the municipal manager must be aware of his obligations under section 66(1). And so blaming council for the instructions he did not receive can't be a valid basis on which to impugn the validity of Mjali J's order.
Well, I don't seek to defend the municipality's conduct, and of course they should have timelessly filed an answering affidavit. There's nothing that can gainsay that. But the realities of the situation are that it was unopposed. The attorney for the respondent had withdrawn, and the unfortunate reality is that imposes obligations on council then appearing as to.
Yeah. Okay. Can I just move on to another question? The Ms. Ndabeni and we're asked to make an order to purge the contempt. Now, the implications of such an order for the PFMA, will that, well, perhaps you might want to comment on what the implications might be.
If we can just, I just want to get the,
Page 61, 161 at the bottom, paragraph C.
I just want to, I thought I beg your pardon, Justice, what I'm looking for is the Mbenenge order, because I think that's the one that directly regulated the proceedings. I get that at page 207, which I think is in volume 3.
Yeah.
On page 207.
Yeah.
So my submissions in relation to the order would be these. If one starts with paragraph 4, well, we go right to the bottom. Paragraph 5 was the paragraph that was deleted in the hearing before Griffith's Day. Paragraph 4, if the court is with me in relation to the contempt, then no order can be made in terms of paragraph 4 because there is no contempt that is required to be purged. So paragraph 4 would fall away. And then if the court is with us in relation to both the contempt and the nullity arguments, obviously paragraph 3 would fall away. If the court is with me in relation to the contempt, but against me in relation to nullity in the sense of Mutala, then it would be correct to find that the first respondent was his conduct was unlawful with reference to the order of Mjali J. But I would respectfully submit in relation to that the court there must have a discretion as to whether or not it should grant that particular relief. If it is apparent on the papers, so leaving aside the Mutala basis where facially there is nullity, if it's apparent on the papers that, and going into the facts, that there is in fact a problem with the validity of the judgment, then I would submit the court has a discretion as to how it deals with the unlawfulness part of paragraph 3. It may decide that it wants to make that order because at the time it was unlawful not to comply. But I would submit it's also open to this court to say, to look at the position as to what happens going forward. Because if indeed, factually, this position is not provided for in the staff establishment, then the same dilemma is still faced by the municipality going forward when this battle is over in relation to these proceedings. And I would submit that's a relevant factor for the court to take into account and to exercise a discretion as to whether it can make an order or should make an order in terms of paragraph 3, if it does make an order in terms of paragraph 3, then with respect, it should say in its reasoning, in its judgment, whether it is doing so historically in relation to a non-compliance that took place, or whether it's doing so prospectively in the sense that there is a position on the staff establishment, that's the finding, and that's the basis going forward.
Well, what about something in between? Because we don't know enough to say either prospective or retrospective. And if we made the order, would this be something that the officials will have to deal with Treasury? So it's not our problem, but it's a problem that stays with the municipality and holds them accountable.
I just don't know enough about the applicable treasury related legislation to know to what extent they do or don't have a role here. But certainly there remains unresolved as far as the future is concerned, the difficulty that budgetary issues seem to have informed the nullity provision. And it may well be that the current incumbent of that position is cast back into exactly the same difficulty, where the position isn't on the staff establishment, and he too is faced with personal liability because the framers of the legislation don't want an obligation to be incurred by the public person in respect of that salary.
Thank you, Mr. Dodson. Thank you, Justice Madlanga.
Just briefly, remaining submissions, we submit that it's wrong to characterize the willingness at a point before finally confronting again Section 66, the willingness to look at to look at implementation as the way of dealing with Njali's order once the attempt at appealing to the Constitutional Court had failed. We say that's a sign of bona fides, not of mala fides. The official says, and it's uncontested, yes, we decided to look at implementation of the order.
Mr. Dodson, now that we've stopped, at least for now, asking questions, how much more time do you want?
I won't be longer than 5 minutes. I won't be longer than 5 minutes. Probably less. I'm close to completion. So we would submit that's a sign of good faith, not of bad faith. Of course, the official must look at compliance once they've missed the boat as far as an appeal is concerned. And they did, and they said they were confronted with section 66. So we say that certainly can't be held against them. It should be held in their favor. I believe those are all of the issues that I needed to respond to. So the relief we seek, I've already indicated in my main argument. Unless there are any further questions from the court, those are the submissions on behalf of the applicants.
Thank you very much, Mr. Dodson.
Thank you, Justice Madlanga.
Thank you to both counsel. Judgment is reserved. Court adjourned.
Today's proceedings have concluded. The host will now terminate the meeting.